Hi, I'm Burney from Next Point, and we are talking with Tom O'Connor, the author of the book eDiscovery for the Rest of Us, which has recently been republished with Next Point. Now, Tom, there were several amendments to the Federal Rules of Civil Procedures, more specifically in the years 2006 and 2015. Now, just maybe give us a flavor. Why were these amendments so important in these years? And what is it that lawyers need to know about these specific amendments to the Federal Rules of Civil Procedure?
Well, first and foremost, I think that they were necessary from a codification standpoint.
Mm,
Prior to 2006, electronic discovery, electronic documents were around, mostly in a lot of big cases. There was a major IBM case, for example, but things were starting to pop up like the breast implant litigation,
mm.
the Arthur Anderson case. And of course, you had specific judges in specific districts handling those cases and those matters. Judge Shindlin in New York, she's
Yes,
retired now, but she handled the Zuba Lake matter, which
right.
is very famous for several of her rulings on e-discovery. Those are all pre-amendment. Um, and so, much like the advertisement on TV, Judge Shindlin would say something, and somebody in Oklahoma would say New York City.
Right.
Not the way we do things down here in Texas. And one judge literally said that. So you needed just as any field, you needed some codification.
Right.
And then of course that also added some definitional structure. Here's what we're going to define to the rules. It picked up some steam in the second round, dealt with some specific issues that had come up, but one that had also come up right after the first round of rules was the cooperation proclamation, which was not
Yes.
from the courts. It was from the Sedona conference, but it was immediately endorsed by
Yes.
530 judges and became part of the notes to the 2015 amendments, as did the expansion a little bit of the wording to say that all matters in front of these FRCP1, all matters in front of these courts shall be handled by the parties and the judges in a manner that is just, speedy, and inexpensive. And so that was very important, which leads into the answer to your second question. What do lawyers
Yeah. Right.
know about this? Do not ignore the notes to these
Yes.
rules, my friends. The notes, the committee notes to these have some explanations of some of the terms and the discussions, like the cooperation proclamation, that are followed closely by the judges. So look at the notes and look at the, as I said in a webinar I did a number of years ago. Read the rule book, Jacopotamus.
Yeah.
These are rules. They're not, Pirates of the Caribbean
Right.
guidelines. Okay, these are rules. We have a magistrate judge down in my hometown in New Orleans, Magistrate Judge Roby, who, when asked about the meet and confer rule, said, the problem with the meet and confer rule is all you folks treat it like a drive-through daiquiri window, something that's legal down here. He said,
Yeah. Right.
you're supposed to get together and confer. That means talk. Okay,
Yeah.
it doesn't mean send an email. So read the rules and understand the rules, because if there's a dispute down the road, especially with regards
Right.
to early disclosures and meet and confer, if there's a dispute 6 months down the road, the judges are going to look back and say, you didn't do this, so you're out of luck. You should
Right.
have done this. It would have been nice if you did this, but you didn't do this, so sorry.
Yeah.
Read the rule book, Shankopotamus.
That's great, Tom. And I like that because I like your emphasis just now and in the book on how it's like, hey, if you don't understand how to talk about this or how you should do a meet and confer, that's exactly what you go through some of the details in the book eDiscovery for the Rest of Us. So thank you all for joining us, and be on the lookout for your opportunity to get a copy of Tom's book eDiscovery for the Rest of Us. And Tom, thanks for joining us.